Okay,
Okay,
go
you
ahead.
there?
Yep.
Okay, because I couldn't hear you. All right, ladies and gentlemen, gentlemen and ladies and gents. I know it has been a moment since you've heard from me, but please don't misunderstand me. It wasn't that I didn't want to be heard by you guys or have you guys hear from me. It was I've been busy. We've been having several courts sit up here and interfere with the arbitrations. They've actually gone about saying that the Sick Home Arbitration Association is an invalid arbitration association. So when you all get a chance, and I should have had the computer screen pull up the Federal Arbitration Act, section number 5. So if I can have you pull up in the background the Federal Arbitration Act, section number 5, so that we can show everybody that according to the Federal Arbitration Act, it is the parties who choose the arbitration association. And what makes a valid arbitration association and a valid arbitrator is that the arbitrator is chosen by the parties and that the arbitrator gives the parties an opportunity to participate in the arbitration hearing and that the hearing is fair. That is what constitutes a valid arbitration association. But what the courts have been saying is that SICOM does not appear to be a valid arbitration association. That's designed to interfere with the process. So we have advised everybody, we did a video telling everybody that they must appeal their case. Here is the point. If you have an arbitration that you have done and it was against any entity of the United States, such as the Federal Department of this or the Federal this or the Federal that or the United States Administrative Office of the United States Courts, and so on and so forth, you do not bring your appeal to the District Circuit Court of Appeals for the 9th or the 5th or the 4th or the 3rd Circuit. You bring it to the United States Court of Appeals for the Federal Circuit out of Washington, D.C. That is an Article 3 court, and they specifically deal with cases that are against the United States. They are not a circuit appeals court, okay? They are an Article 3 court. They are not by law, they are an Article 3 court. So that is the suggestion. What I am going to be doing is we're going to be putting up all of our responses, my responses to the court, so that you all will have the case law, you will have the arguments, you will have the points to bring up in your appeals. Yes, the appeal is going to cost you. What I would suggest is you do the fee waiver. Now, what I do know about the United States Appeals Court for the Federal Circuit is that they don't like granting fee waivers. Don't know why that is. So we're paying the fee, but I am trying to pave the way for everybody. That's the first thing. The video that was done, I just wish so many people would pay attention to it because it has the information on the adverse possession. Now, what everybody needs to know, the situation as to what's going on out in that wonderful world, if you go back and look at all the videos I did on Ebola and TTOPP, you'll see that that's the reason why TTOPP.org was set up, is for just this situation. I told all of you in advance what they were getting ready to do. I told all of you in advance, I'm going to say it again, what they were getting ready to do. Pay attention to those videos because there's nothing else I can say at this time because everything is already said in those videos well before it even happened. Okay? I'd like to talk about all that right now, but there are so many other things I want to talk about. Let's get back to the arbitrations. Those of you who had arbitrations done and your arbitration has been a year and you haven't gone after confirmation, you can come back to the organization and ask them to reissue your award, extending the confirmation period. Okay? That will, for each person, they have to extend the confirmation period. They'll have to notify the other party. So that would be $50. The reason being because it has to be mailed out to every party, and the person has to process it. So it's like having another arbitration done. But what they will do is they will reissue the arbitration award, and they will extend the period in which you are able to get the award confirmed. The rest of you who've gotten your awards dismissed and you have not appealed it within the 14-day period, go back into that court. We put a document up there. It is a reconsideration document. It brings up the points challenging the court's jurisdiction, bringing up all the points that are necessary for you to get it either reheard or to win on appeal. Okay? Okay, you've been trusting me thus far up to this point, including the defrauded homeowners of America. Please don't think that I've forgotten about any of you. Okay, that's what I've been working on. I told you all that I was going to be in here and I was going to take care of my education. Well, that's what I've been doing, educating myself on arbitration. If there's anybody out there who knows more about arbitration than me, I promise you that person is a liar, because that's all I've been focused on the whole time I'm in here. Get your appeals done. Some of you are not going to be able to do your appeals because you have no concept, no clue as to how to do an appeal. Don't worry too much. We are coming to your assistance shortly. We're going to put up certain documents on the site so that it'll give you an idea as to what's going on and how to handle it. And, sorry, that's me rocking back and forth. We're going to put up something so that you guys will be able to see what's going on, and we're going to map out everything. We are handling our appeal. Our appeal should take care of everything for everybody else, including them trying to badmouth the Sitcom Arbitration Association. Now, those of you with the QPAKs, please understand, all of you with the QPAKs, you're going to get your default. You're going to get the organization sending you out a notice that the other party has been served. We're going to send out notices of default for you, okay? And that's without you having to do anything with arbitration. With the QPAKs, even if the economy should fall, even if they should come up with a new currency, that's already written into the contract. Everybody is worried, will this still work? Will I still be able to do this? Yes, the contract is written specifically for this. As I told all of you, knew about all of this in advance. So I anticipated putting that into the contract, and it's there. Okay, the contract was solidified for your benefit. All right, I'm trying to remember everything because I didn't write this stuff down. I just wanted to say that those of you who need to get the arbitrations done, you need to get them done now because they're getting ready to change it. It's called House Bill, and it's the United States Congress, House Bill 1423. House Bill 1423 is called the FAIR Act. That is where they are trying to stop you from using arbitration to handle any civil complaint against government. Okay? And they're also trying to add the federal rules, so you have to comply with the federal rules. As of now, anybody who's done an arbitration and they tried to get an injunction against you, the court's tried to sanction you, or the court has tried to get a declaratory judgment against you. Those are all illegal acts. Supreme Court in Archer.
This call and your telephone number will be monitored and recorded.
Henry Schein in 2019 decided that that is not part of the Federal Arbitration Act and the courts have no jurisdiction. So you got a QPAK, you got the QPAK, and you have your arbitration with the incarceration contract. We're just now starting to process the incarceration contracts, and we're adding a habeas corpus provision to the arbitration award because that's what the Congress stated that the incarceration contract amounted to, a release dismissal agreement. So because of that, we're adding a habeas corpus because habeas corpus is a civil issue, not a state issue. And we're putting a release document in there, so there's a release provision. Just bear with us, okay? No matter what happens in our world scene, we're still going to be processing the arbitrations. We're still going to be going through courts because even if you don't
Ready? Go.
Yes. All right, ladies and gentlemen, what you don't know and what you don't realize is that the facility here interfered with the recording while I was recording, so they cut it off so that you didn't hear the ending of what I was saying, and I finished a whole lot. So let's go ahead and say that the incarceration contract, Congress has stated that it operates as a release dismissal agreement, dismissing the original case and permitting the release of the person. That's called habeas corpus. We've added a habeas corpus provision to the arbitration awards concerning the incarceration contracts. Now, the way the habeas corpus works is because the arbitrator has the powers of a judge between the parties, and we have the case law documenting that, because they have the powers of a judge, which are civil powers, and habeas corpus is a civil proceeding, and there is nothing in law that says a habeas corpus must be issued by a district court, a superior court, and blah, blah, blah. The law only requires that only the executive branch, the judicial branch, or the legislative branch may issue habeas corpus. Well, an arbitrator has both executive powers, because it's the Federal Arbitration Act, and judicial powers under the Federal Arbitration Act. And so the contract between the parties, and because it's between the United States has the authority to delegate the authority to another party to issue a writ of habeas corpus. And that's what the contract does. It delegates the authority to the arbitrator to issue a writ of habeas corpus. And so that provision is being done for all of the incarceration contracts as of now. And we have a template that are being followed as long as they're in default. As long as they're in default, the arbitrator has the authority to do that. Okay, because that's the purpose of that contract. As I stated before, the way the contracts are written, it doesn't matter if the economy takes a nosedive tomorrow to where the point the dollar bill is worthless. That's not the point, because it's either dollar value or land value. Read the contract. It should be near the arbitration section that you'll see that thing about being paid in land value if the dollar is of no value. And plus, we already know that the dollar has no value. Okay, got that taken care of. There'll be more information coming soon as to the process, but as we told you, the Defrauded Homeowners of America, the other individuals whom I've been helping, we have Hubbard, Leon, and Demerit. Those three I am working on. We have a situation now where the courts have taken one of our arbitrations and have, to try to interfere with everything, converted it to a civil action, even trying to set up their own arbitration hearing with the company without the parties agreeing to it. We're okay with that. We're going to let them do that. They're even ordering us to pay the full filing fee. Ladies and gentlemen, arbitration is a miscellaneous matter. It is not a civil matter in the form of a litigation. Arbitration is not litigation. Now, if you want proof of that, just look at Section 3 of the Federal Arbitration Act. It says that if there is an arbitration and the person does a motion to compel arbitration, that the court must stay the litigation or the civil proceeding in lieu of the arbitration. So arbitration and litigation are not the same thing. So when you file for a motion to confirm arbitration award, that is done under the Federal Arbitration Act, and it should only cost you $47 to file in the district court. But you're going to have to do your research, and you're going to have to be able to point this out to the clerks when you make your filing. The judge who's ordering us to do that, we've already put in our objection to that. We're going to pay the fee because we are trying to go after the default, because the other party has not put anything into the record. And the court has documented that they've not put anything into the record, and this matter was filed in January. So right now we are processing it as we're going after the default. Now, those of you who do have your contracts, after you do the contract, after you've gotten everything done, you do not have to go after confirmation. You can go after garnishing of wages. You can go after placing liens on the party. You can go after properties by doing a writ of possession, because the contract is the binding instrument. Remember, the contract operates the same as a deed of trust. Now, although you may not be able to evict them out of the property because there's no specific property listed, except for if it's one of the contracts that lists your personal property, such as your home, you might be able to do that, but I can't tell you how, because I haven't given it a full thought, because I just thought about that just now, because of it being an eviction, because you do an offset on that. So yes, I would say that you should be able to do an eviction on that. You just have the courts arguing with you. But again, under the Federal Arbitration Act, the courts can argue with you because the arbitration award is final. Under Section 12 of the Federal Arbitration Act, it says they have 90 days, 3 months, that they have to contest the award. If they elect not to show up at the arbitration hearing, and they can't contest the award. When they elect not to participate in the arbitration hearing, the law says that they have no recourse. They cannot contest the award. If they wait past the 90 days, the court cannot vacate the award. That's why I advised everybody to wait the 90 days after they receive a copy of the award. In its rotation, it's only 3 months. So wait the 90 days after they receive the award, and they have no recourse. With that being said, I'm not going to keep this because we already did the beginning of this, and now we're going to let the video continue after this. We let it continue, so now we have the full video. We'll be doing more videos shortly, so just stay tuned. It won't be months like it has been, but it should be another one up by the end of next week. We'll get that information to you guys. We'll tell you everything that's going on, get you guys up to date. Those of you, remember, they are doing what they're doing on purpose. Do your research. Agenda 21 is the issue. That's all you have to do is look up Agenda 21. There are a couple of videos out there. I've done several videos on it. That's what they're implementing right now. Just all you got to do is sit back and pay attention. With that being said, I am going to say, ladies and gentlemen, ladies and gents, and gentlemen and ladies, thank you for
This call and your telephone number will be monitored and recorded.
being interrupted by that lady, and have a nice day.